Nĩ kumĩrĩte gĩcanjama kĩnene igoti-inĩ mwena wa Naikuru thutha wa mũira wa mbere cira-inĩ wa ũrĩa warĩ mũtongoria wa kĩama kĩa Mungik Maina Njenga kũringĩka na kwĩrigwo rĩrĩa akwĩhĩtaga na Bible nĩguo arute ũira wake. Mũtumia ũyũ nĩ Mathaini Law kana nyina wa mũtumia wa Maina Njenga. Igoti rĩu riugĩte mũira ũyũ ndangĩthiĩ na mbere kũruta ũira wake nginyagia rĩrĩa akaigua wega na agĩe hinya wa kũrũgama igoti-inĩ. Maina Njenga akoretwo arĩ moko-inĩ ma thirikari na gĩthagathago kĩingĩ kumana na mwerekera wake wa kĩũteti na biacara ciake. Arĩ nginyagia na mahĩtia ma kwendia ndawa cia kũrebia ta bangi. Wĩrorere ũrĩa gũthire na mbere.
Yes. Can't manage the code. In addition to what my senior has submitted on in this Article 50, that is Article 50 clause 2, you'll also look at paragraph J. To be informed in advance of the evidence the prosecution intends to rely on and have reasonable access to the evidence. Up to now, we do not have reasonable access to evidence, because the witnesses are the accused persons. This can only happen in a jurisdiction where there are no procedures, and especially as enshrined under Cap 75. Secondly, Your Honor, paragraph K provides that to adduce and challenge evidence, the prosecution to adduce evidence, the defense to challenge that evidence. So we are in a serious constitutional dilemma, as counsel says. How do we challenge this evidence? How does the prosecution adduce this evidence? When does the accused person convert from an accused person to a witness? And where is the line? Counsel submitted on the question of to refuse to give self-incriminating evidence. And Your Honor, this is a very, very, very serious transgression. Because this article is protected article under Article 25. Article 25 says that these are some of the non-derogable rights. You cannot derogate this right. You cannot limit this right. The right to a fair trial. And as such, Your Honor, many a times this court has said that it has no ability to interpret or apply the Constitution. But we are not asking you to interpret it. We are asking you to apply it. Just in the same way you would apply the provisions of the Constitution and Article 49. If you could grant an accused person bail under Article 49, and that is the application of the Constitution, why then should the court close its eyes to the imports of Article 50? You know, as a sample and perhaps pass over to my learned friends, it is important also to look at Article 10. Under Article 10, which provides for the values and principles of governance, this court is enjoined. This court is enjoined in its jurisdiction to uphold the provisions of the Constitution. Among that principle, Your Honor, is the principle of the Bill of Rights, to which we are submitting to this morning. So, Your Honor, we are in a serious dilemma, and may I just mention that the evidence of Daudi Mungik, the evidence of Daniel Mutua Jeroge, the evidence of Simon Mungai Madu, the evidence of John Kuria Karino, the evidence of Peterson Wanjao Girango, the evidence of Samuel Kanede Gide, the evidence of Julius Domo Kamau, the evidence of Peter Njenga Wambui, the evidence of Philip Kagiri Jeroge. You know, those are your witnesses today. These accused persons are your witnesses. Your Honor, we are ready to proceed in that circumstances, if we can.
Good morning, Your Honor. My name is Aaron Luby, advocate. May I apologize? I was actually running upstairs to look for you to come here so that we can deal with this matter. The questions that they have discussed, my colleagues have discussed, are important constitutional questions. We are in a period that now we want to violate the Constitution and defy the Constitution at the behest of the prosecution and in promotion of impunity. we expected that the Constitution of Kenya, and if you allow me some bragging rights, this Constitution is the first one that I was bought from the government printer by myself, and the first one to be bought by any citizen from the government printer. The second point of allowing me bragging rights is that I participated in the process of making this Constitution. We did not expect that we should have a prosecution that would violate citizens' rights. Even if any citizen could be criminal, yourself, myself, anyone here would be engaged in a criminal activity. But we are entitled, all of us are entitled to a fair trial. One of the principles, and may I again say what my friends have said, you cannot compel a suspect to record a self-incriminating statement, choose him as a witness against himself, and choose him against as another suspect in one transaction. I don't know, because I was upstairs trying to chase for your chambers, and I found that they were closed. Thankfully so, that is how it should be. I recognize that. The fact is that statements from each one of these should not be used against another. And that's not an issue of fact, that's an issue of law. So what do we do? How can they be tried and then they are supposed to be inseminating the evidence? The additional and possibly my last point is that some of the suspects, particularly the first accused, has a similar matter pending in Nairobi. I suspect my colleagues may have said this in their absence. Similar matter pending in Nairobi, trying to create an impression that he is a person of notorious criminal character. That is a matter that should be referred to the High Court. I know you cannot refer it to the High Court without, you may do so by way of reference. But it is also possible that you say, I will give you time, give us 30 days, we file an application in the High Court to transfer either the Nairobi matter in Makadara to this court, or this matter to Nairobi High Court, so that the High Court in Nairobi can make a determination on whether it should be determined that the two matters be consolidated because the facts are similar. Even if they are manipulated, that is an issue we will argue before that court, because I think they are manipulated. But even if you are criminal, even if you are rapist, you cannot be raping women around every day. it is completely incorrigible to imagine that a man like the first accused, actually I should call him the first suspect, not accused, that he is committing offenses right, left, and center every day, every month, every week, every year. Even terrorists' plan, Osama bin Laden took so long to bomb the 9/11. You cannot say that this person is available to commit offenses of the nature he is accused of, both in Nairobi, Makadara, and here, every day. And for that reason, and I don't want to spend too much time, I would like that you refer the matter to the High Court for the constitutional interpretation of the questions we have raised, or B, you give us time to file an application before the High Court to transfer this matter either to Nairobi or allow us the time to consider whether we want to transfer the matter in Nairobi to the High Court in... No. I think it can only be one. Sorry, I apologize. It can only be one way. It is for the High Court of here to transfer the matter to Nairobi, and then Nairobi determines, or subject to what Nairobi says, then we can determine how to proceed. But it is not possible. It's actually an affront to the Constitution. It's an abuse of the law. It's an abuse of the, not the jurisdiction of the people, but the sovereignty of the people of Kenya to have these charges brought up against these men. Can you imagine if we came to a funeral meeting in your house and then someone said, we have come for a Mungik meeting? What is that?